the patent related basic things, like how to search a patent, okay, or how to do a patent search, or what is the basis of basic parts in the patent document. Okay, so we will start with what are the intellectual properties. Okay, so I am going to the uh, presentation section. Okay, so today's section is basically related to the patent. So still we will go with the some intellectual property, whatever the types of the intellectual property, because what is to be patented. Okay, how we should differentiate the patenting with copyright, with the geographical indication, with the trademark. Okay, sometimes what happens in general discussion in daily life, we sometimes say this, we have patented the XYZ name, but it's not the actual, but just for a joke or for a communication, we are doing this patent or like that. But actually, it doesn't work like that practically. So I I I want to just differentiate that part, so you will understand what is exactly get patented and what how it differentiated from other intellectual properties. Okay, so so mm, this is the title of our today's presentation: Protecting Invention, Patent Search, and Indian Patent Law. Okay, so what is intellectual property? Okay, so this is the basic definition, not the definition, but just understanding, basic understanding. Creation of mind, like invention, artistic work, or design. Okay, so creation of mind for what 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 is the creation of mind? Okay, so we generate ideas. Okay, we make product out of ideas. Okay, or we develop many things out of ideas. Okay, so that is the creation of mind. Okay, so we think about it and we make it possible. Okay, so that is the creation of mind. Okay, then that we call it as intellectual property. Okay, so it's intangible, so we cannot actually practically just like land um, uh, or gold or like that. We cannot say it. So we generally call the patents as the intangible property. So it cannot be directly measured or weighed. Okay. So it provides the legal right for protection and commercialization. What is intellectual property? Intellectual property. What is intellectual property? That is the creation of mind. Okay. So intellectual property provides legal rights for protection and commercialization after protection of after using the proper protection of the intellectual property. Okay, so for example, patents, trademarks, copyrights, and trade secrets. So uh, all of you have understood what is intellectual property. Intellectual property is the creation of mind. Okay, so somebody creates an idea, make product out of it. Okay, or somebody um, generate some product or which is different from the other's product. Okay, so that is the intellectual property. So what types of major intellectual properties? Okay, so patents. Okay, patent protects the inventions. Okay, suppose some researcher have developed a product. Okay, a pharmaceutical product or a mechanical product or like that. Okay, or a process of preparing some products or like that. Okay, so that is covered under the patent. Okay, what is the trademark? Trademark is that what is if you break the words trade and mark. Okay, that is the for business. Trade, that is all we know about what is trade. Okay, and the mark is what we all we know. That mark may be over or a symbol. Okay, or any graphical presentation. Okay, that is trademark. A logo or a name for the business. Okay, that is trademark. It protects brand names or logos. Okay, generally it protects brand names or logos. Okay, so we are not going directly the X language. Okay, because X language maybe all students may not be understanding. Okay, so another it's the X language means there is the Indian Patent Act 1970. Okay, if you will go and read Indian Patent Act, maybe if you are not a law student or you are not well familiar with the legal language, it may be little harder for you. Okay, so for the student's perspective or non-legal person's perspective, it's in the simple language. Okay, so copyright is the protect creative work. What is creative work? That is drama. You all you know that is YouTube. When sometimes a YouTuber copies another YouTuber's video, then there is a copyright strike. Okay, then they have to withdraw the video or YouTube remove that video. Okay, that is the copyright part. Also, we can file a copyright for books. Okay, softwares, programs like that. Okay, that is the copyright. All people are aware of this. Even you go to the film or a film theater, so you will well aware of that there will be a copyright instruction or a copyright disclosure that it should not be copied or like that. Okay, so then trade secrets are not registered. Okay, sometimes what happens, companies feel that if we will register a patent or make whatever copyright or anything or trademark, okay, so when it comes to the public disclosure, we will lose um, our technology or our secret product. Okay, so they want to keep it secret. Suppose there is a product like food product. Okay, there is an example of trade secret that is Coca-Cola. Okay, so how Coca-Cola is prepared, what are the ingredients of the Coca-Cola? That is a secret. Okay, so they don't reveal it. Maybe other people know, but it's not publicly known, well known. Okay, so there is another thing called geographical indication. In the name, it is there geography and its indication. It links the product to their region. Okay, geography means generally we call it as a region. Okay, so Kolhapur chappal, Darjeeling tea, that is a geographical indication. These are the some intellectual properties. Okay, patent you can register, trademark you can register, copyright you can register, geographical indication you can register, but this trade secret is we cannot register. Okay, so I have explained these types of IPRs, but these are the examples. So patent, what you can patent, mRNA vaccine formula. Vaccine formula you can patent. Okay. Then trademark, you know Tata, Google. These are the registered trademarks. So you cannot copy the name Tata for your motorcycle business or vehicle business. Okay. You cannot copy this Google name for your any web-based business. Okay. In copyright, what is copyright? You can do a copyright over novel or song. Okay, trade secret. I just have explained the Coca-Cola formula. Geographical indication, that is Darjeeling tea. So we will not discuss much about it because our main aim is to discuss about the patents. So I have covered all the other intellectual property. So now from here onwards, we will discuss about the patents only. Okay. So importance of patents. Why patents are required? Okay. There is a trademark system is there. Other systems are there. But why patents are important? Okay. Suppose these are the points. It encourage the innovation, economical growth, protect R&D investment, grant monopoly right to the inventor, can be licensed or sold for profit. But uh, as a part of discussion, I will just create a question. Okay, suppose you do a research. Okay, you invest money. Okay, and you nothing get nothing out of it, or you make a product, you sell it, but other person copies it. Okay, how can you how will you have the edge over that? Suppose you are a scientist, you discover a drug. Okay, and you know that this drug cures cancer. Okay, but you make the drug, forget about the permissions and all these things. Just for example, you make the drug and sell in the market, and you have invested a lot of money to research that thing. Okay, so when you go to the market, you sell it. Other person see your product and he copies it. Okay. Once he copies it, so he start to sell. Okay. So you have invested a lot of money. You have done a lot of. You have wasted a lot of time. So what do you get? Other person can copy it easily within a month or within a days without a lot of investment. He just copy. Okay. So he can just make a identify your product. He will synthesize it or formulate it. Okay. So all your investment, what is the use of that? You have done a very good work because there was no drug for the cancer. Okay, you have done a very great work. So what you get? So you get a patent. So if you apply for a patent, you get a protection. Okay. So you get a protection. So others people cannot copy you. And if you get a patent, your patent granted. Okay. So other people cannot copy it easily. So they have to take a license from you, or they have to take the patent assignment from you. Okay. So without your permission, they cannot copy it. So that is the main importance of this patent. Okay. Who create the invention, who does the research, who invest, he gets the benefit from this patent system. Okay. So this is the basic importance. Okay. So you know the Edison's bulb light and all these things. Okay. So Edison's patent is that it was filed in 1879. Just common example, so everybody can understand. It was got patented. It's a There are maybe other patents on the light bulb, but it's one of the Edison's patent. I have not mentioned the number here. You can search it on the Google. Edison's patent. Okay, so it was patented in 1879. So what can be patented? So this is one of the type. So maybe I will in patent search part I will show it to you. Okay, so it helped to revolutionize indoor lighting, enable growth of electric utilities and G. So this can be patentable. It's an example of a patent. Okay. So in India, uh, patent system is governed by the Indian Patent Act. Okay. So Indian Patent Act is there. So how the patent system should be governed? It is all there in the Patent Act. Okay. And on the base on over this Patent Act, there are patent rules. Okay. Various forms, fees, and all these things are there. But the main basic framework is the Indian Patent Act 1970. Okay, so it was came in the picture from 1970. So what it does, it protects the invention in the India. This patent system governed by Indian Patent Act protects the invention in India. Okay, so it gives exclusive rights for 20 years. Okay, suppose um, you have a new product or process developed. Okay, you file a patent, and after examination and all these things, so it gets granted. You get 20 years of protection. Okay, so it is administered by Controller General of Patents. Okay, administered by Controller General of Patents. Okay, and this is the website. So maybe we'll come into this website later. Okay, so what is the criteria for patentability? Patentability criteria is the main patentability criteria, that is novelty, inventive step, and industrial applicability. But novelty means it should be new. Whatever invention that is there, it should be new. It should have inventive step. Means it should not be obvious. Okay, and it should be industrially applicable. Okay, so um, criteria for patentability, novelty. What is novelty? It should be new. Suppose something you have developed. Suppose all most of the people are pharmaceutical backgrounds. Okay, so patentability means novelty means it should be new. Okay, it should not be done before. Okay, so it should be new. The second criteria is inventive step. Suppose there is a formulation which is new. Okay, but you add sugar in it and you say it becomes sweet. So can you get a patent on this? It's obvious. If you add the sugar to a formulation, it becomes sweet. Okay, or if you add a sugar to any pharmaceutical formulation, it will become sweet. So if you add salt, it will become salty. Okay, as per, so it becomes obvious. You will not get a patent on this. Okay, unlikely to get a patent on this. Okay, then industrial applicability. So industrial applicability is not very strict because everybody discovers or develop a product for a purpose. Okay, so it generally, suppose you do a develop a drug, it will be industrially applicable. If you develop any process or like that, it generally becomes industrially applicable. Okay, unnecessarily why one will develop it. Okay, so explaining novelty and inventiveness. Then again, I will just go on the novelty. Cannot be published anywhere before. Okay, means novelty. How generally a novelty is checked? It should not be published anywhere. Okay, on the date of file. Okay, when we go for the new patent file. Okay. Inventive step. So it must show technique. It must show technical advancement and non-obvious approach. Means some technical advancement should be there. It's not like a sugar example, just you add a sugar. It is not a technical advancement. Okay. It's just a it's just a use that you use the sugar, okay, and make it sweet. Okay. It should be non-obvious approach. If if you add sugar, it becomes sweet, then it's obvious. Okay. So it should be non-obvious when you want the patent to be get granted. So this is patentability criteria. Okay. So apart from this criteria, novelty, non-inventive step, and industrial applicability, there is section 3. Okay, Indian Patent Act, section 3 of the Indian Patent Act. Okay. So as per this section 3, there are multiple types of inventions which cannot be patentable. Okay. So anything which is frivolous or claim obviously contrary to the well-established nature means anything which is danger, it is wrong or anything describes anything something wrong, it's not patentable. Okay. Something then a second point is primary or intended use or commercial exploitation or intended use for or commercial exploitation, which is contrary to the public order or morality. And basically, what is it say? It's a legal language. So I have just explained in the simple language. Means anything which is harmful to the human or animal, that is not patentable. Okay. Then third point is scientific principle, just like Newton's law. Okay. If you patent a Newton's law, what will happen? Okay. Or if you patent a gravity, just take an example of gravity. Gravity is a natural phenomenon, right? So you cannot patent that. Okay. It's a natural thing. So, or it's any scientific principle, you discover it, it's not a patentable. Okay. So then this is a very important section in relation to the pharmaceutical composition. That is section 3D. When when a pharmaceutical patent is not a patentable when it is a mere discovery of new form of known substance. Okay, new form of known substance means, okay, I will come to that. It's in the later part. Okay, new form of known substance which does not result in enhancement of known efficacy. Okay, of that substance mere discovery of new property. Okay, so what it covered? Salt, ester, ethers, polymorph, metabolites, pure form, particle size, isomers, mixture of isomer, complexes, and combination. In simple language, what I am telling you. So this section covers somebody develops a new salt. Suppose you have developed a paracetamol. Somebody comes and say, I have developed new salt paracetamol. So give me a patent. So in that case, if it doesn't give the significant enhancement in the efficacy, okay, so until and unless it gives the significant enhancement in the efficacy, it will not get a patentable. Suppose some people what they do, they make esters, polymorphs, and all these things, pure forms. Suppose somebody says this is 98% pure, somebody says it's 99% pure, so give us a patent. So this purity on that purity you will not get a patent. Somebody says particle size, but if that particle size doesn't enhance the efficacy, that is also not patentable. Okay. So then isomers and all these things. So see, this section 3D is very important in perspective of the pharmaceutical compositions. Okay. Then there is the section 3E. Okay. What is section 3E? Sometimes what happens, people mix multiple things, just like a sugar example. People make a mixture of multiple things. I will just explain in the simple language. I will not, you read it, but I will explain it in the simple language because understanding is the most important part, I think, as far as these students or all these new researcher perspective. Okay. So this section is what it tells, mere admixture resulting only in the aggregation. Okay. So some people, what they do, they mix multiple drugs together and they say this is also beneficial for diabetes. This is also beneficial for lowering the cholesterol, but they do not enhance the efficacy. Okay. Suppose there is a diabetic drug which is 200 mg and it separately provides anti-diabetic action, and there is a cholesterol lowering ingredient which separately does its part. Okay, so it's a mere admixture. Okay, if they combinely give a synergistic packet or extraordinary packet, then it is patentable. But just mere mixture without any significant enhancement in the efficacy, it's not patentable. Okay, so these are not related to the pharma, but I will just explain. Arrangement and rearrangement or duplication of known devices. Means if there is an electronic device and you add a sound effect, you add a lighting effect in it, and you say nobody has done it before. Okay, this is a new device, so it is not patentable. So method of agriculture and horticulture. Somebody say I water the plants differently. Okay, watering of land like that. This is the method of agriculture. Sowing of seed. That is not patentable. Method is not patentable. But you can patent a agriculture. You have developed a device for agriculture purpose. Suppose you develop a uh, um, various tools for tractors and all these things. That can be patented. Okay. So another part, medicinal procedure. Just as if a surgeon does a surgery, that is also not patentable. Okay, the method of surgery. Okay, plants, animal as a whole part not patentable. In some cases, microorganisms are patentable. Okay, then mathematical and business methods are not patentable. Literature, drama, that is not patentable. That is covered under the copyright. Okay, so then mental act is not patentable. In presentation of information, that is also not patentable. Proper, it means suppose somebody presents something that is not patentable. Topography of circuits, just electronic circuits. Okay, that is also that topography is not patentable. Then traditional knowledge, which is it is as it is there in the literature, that is not patentable. Okay, until and unless it's if you combine use that traditional knowledge and it gives some beneficial effects, that is not patentable. Okay. Also, atomic energy related inventions are not patentable. Suppose somebody develops something uranium and all like all this like that. Okay, that uranium or that bomb. Suppose somebody develops an atom bomb. Okay, so that should be patentable. It should not be patentable because it is harmful to the public. Okay, so atomic energy related inventions may not be patentable. Okay, there are certain cases. There are secrecy direction and all these things.
Okay, excuse
So,
me, sir. Excuse me, sir.
yes,
Can you give me 5 minutes to introduce our new program that is going to schedule for 7 days?
sure, 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 sure,
Yeah.
sure, sure.
So,
Yes.
good evening, everyone. Here, Dr. Bandu Chatale, and I conduct so many workshop to training the pharmacy professionals. I have conducted so many workshop on a different topic. Like I have conducted a workshop on molecular modeling for drug discovery purpose. I have conducted a workshop on NMR interpretations. I have conducted a workshop on grant writing, research proposal writing and funding opportunity. So we conduct so many workshops to train the professionals. So we have a design. Sir, can you stop your saying so that I can show these people what we are planning to do this? Can you
Okay, sir.
stop?
Okay, okay.
Yeah, yeah. So I'm sharing my screen and I will discuss the detail about workshop. Yeah. So guys, can you see this flyer, sir? Can you see this flyer? Yeah.
Yes, yes, I am able to see, sir.
Yeah, so this is a 7 day workshop we have planned, and in that we are going to learn detail about how to protect the inventions, what are the essential skill in the patent search, and we are going to learn detail about Indian patent law. And we have very esteemed speaker for this 7 day. We are going to cover this for 14 hours, and we are going to start this workshop on 8th May, and it is going to finish at 16th May, and we are going to give official certificate for completion for this workshop. And we have very esteemed speaker, like we have Professor Prashant Kharkar from Institute of Chemical Technology, Mumbai. He is has so much experience. He is a patent agent and he is a drug discovery professional with expertise in medicinal chemistry and computer-aided drug design. And he has managed different drug discovery project with pharma companies. So he's very good in. He has written his own patent and published. He has published around 12 patents. And second professional that is today our speaker that is Bhushan Varpe is also going to teach you how to detail about today is just trial this trailer of this pre-webinar, but in detail we are going to learn everything. So I will show you here. I will show you link where you can click it and you can register here. I just show you how what we are going to cover in syllabus. Just second, I'm pasting it for you people. Just give me a second. Yeah, just give me a second. Just detail everything I'm pasting in chat box, and also I'm giving detail about syllabus. Okay. So I will show you what are we are going to cover in this. We are in the first day we are going to cover introduction to intellectual property and patent. In that we are going to cover detail about IPR rights. We are going to discuss detail about all IPR patent, trademark and everything in detail. Then we are going day two. We are going to discuss in detail Indian Patent Act 1970, its key concept and all objectives and all provision. In day three, we are going to learn about patent filing and examination, how happen in Indian patent systems. And therefore, we are going to learn fundamentals in patent searchings. And in that, we are going to learn all freedom of operate, how to invalidate state of art, landscape, patent classification system, everything we are going to learn on the day fourth. And in day fifth, we are going to learn patent search tools and hands-on practice. Like we are going to search how to use free data bases. We are going to learn how to use vPro patents and everything. We are going to learn how to use search patent on Google patent. And we are going to learn how everything about on patent 7 in the day 5th, and in day 6 we are going to learn about patent specification, claim and the infringement in detail. And day 7 we are going to learn patent licensing and commercialization and case studies. So in this way, in detail, 7 day we are going to learn everything. So and we you are going to learn this within just 1,500 rupees. So 7 days workshop, and we have only uh, fees for this is 1,500 rupees only, and this is limited for today 10 p.m. only. And then only this program we have already scheduled 3 months back. That time we have charged 2,000 rupees fee for that purpose. So today is offered for you people those are going to willing to register. Thank you so much, and I have pasted link in the chat box. Thank you so much, sir. You can continue.
Yes. So, what are the rights of patentee? So, uh, thank you, sir. So, what are the rights of the patentee? So, suppose you get a patent. What are the rights you get? Okay. So, you get, suppose you have developed a formulation or a chemical compound or any mechanical device. So, what rights you get? That is the purpose of patent. Okay. So, what rights you get? Patentee means a person who gets a rights of the patent. Okay. There are two things in the patent. One is the inventor who does the research. Okay, and another part is the patentee. So it's there are two parties, inventors and the applicant or a patentee. Okay, so inventors are the researchers who are credited for their research, and patentee are the rightful owner of the patent. Okay, so what rights they get? Okay, they get these rights. Right to make. Okay, suppose they have developed a product, they can make it. They can offer to sell, means they can offer to sell to other peoples. They can use it, they can sell it, they can import it. Okay. Then um, they have right to stop others from using without consent. Okay. They basically have this right. So only the person who has the patent or person to whom he has given or patent he has given the license. Okay, that person can do it, but others cannot do it. Okay, until and unless patentee or applicant has permitted. Okay, so it is valid for 20 years. Okay, What are the different types of patent applications? Okay. So there is a provisional patent application. Sometimes the patent is not complete, disclosure is not complete. Okay, I will just come to the patent document let. What are the parts of the patent? So why, for what purpose patent is given that you are understood. Okay, so there is a process or a product which is a invention. Okay, so that thing patent is given. Okay, so there are different types of patent application. Okay, there is a purpose of this application. So provisional patent application. Um, it is in the idea state when there is a not all experiments are conducted. Okay, some part of it conducted. Okay, so it idea state we can go for the provisional. So there is a another thing called as ordinary application. Means all patent data is we have with, okay, process and everything is there with us. So we directly go for the complete specification, and then this is the patent of addition, patent ordinary application. Then patent of addition. Sometimes we have already filed patent. Yeah, we have got a patent grant or it's in place. So in that we have added some improvements. Okay, the technology. So that is a patent of addition. Then there is a divisional application. Sometimes what happens, people files patent, but there are multiple inventions, more than two or three inventions. Okay, so in that case, there is a divisional application. Okay, then there is this PCT system and there is conventional system. PCT means Patent Cooperation Treaty. It is for international filing. If you have to file outside India, then you have to go to this either PCT route or a conventional application. Okay, then patent filing procedure. Okay, what is patent filing procedure? In patent filing, we make a patent document, it fill the form, and then it file to the Indian Patent Office. Okay, we file it online or offline. Okay, to the patent office. Okay, means there is a just like you can online, you can file it, or offline also you can file. You can hire a patent agent, you can file yourself. Okay, then it published automatically after 18 months in the journal. Unless if you have filed early publication request, it can be published earlier also. Okay. The patent examination process. Okay. In patent examination process, uh, what happens if you file a patent, then it get published. Okay, then you can file, or at the time of filing, you also can file a request for examination. Until and unless you file a request for examination, it will not get examined. Okay, then you receive a first examination report. Okay, on the basis of the first examination report, that patent will get examined. Okay, then after replying to this examination report, you may be invited for the hearing. Okay. So if there are minor objections, then you can overcome it. Okay. If you are serious objection, you have to defend it perfectly. Okay. So also you have to attend the hearing. Hearing means there is a controller or a government officer who handle your application, patent application, and you have to talk to them. They will take objection that it is not patentable like that, and you have to tell them that yes, no, our patent is patentable and like that. Okay, so you have to take our stand and tell them that this is how we are. This is patentable. Okay, then a grant of patent. If you defend all the objection from the patent office, then it will get granted. Okay, if grant is if all objections are resolved. Then you get a patent number. If patent is issued. Okay. Then enforcement begin with the granted. Okay. Means your patent is enforced from the granted. But you can, um, uh, in infringement cases, you can claim the damages from the publication of the patent application. So what is patent specification? Okay. Patent specification or patent document. Both the things are generally same. Okay. What is patent document? So I will just show you in US patent document. Okay.
Yes, Sunil sir, you have any question? Sunil sir? Yes.
Is somebody has a question?
Anyone have any
Mm,
question till date? Anyone have any question? Okay, sir, you can continue. Thank you.
okay. So what is a patent document? I will show you a patent document. Okay. Just say show. This is a US patent document. I'm showing you a US patent document which is granted. So you can uh, understand it better. Okay, you can. Okay. Okay, this is the US patent document. Okay, I will tell you how to search patent, but this is just to explain what is patent. So this is a document. It covers all the technical part. Okay, so uh, all the people know research paper. There is a title, abstract, and all these things. Okay, there is a specific format how patent is written. Okay, so this is a US patent document. I have shown you US patent document because US patent documents are well formatted as compared to the other countries. Okay, this is a US patent document. It's a granted patent. So this is the patent number. Okay, this is the kind code. Okay, okay, this is the kind code V2. Means it shows the state of the patent. Okay, so this is the title of patent. That is storage table formulation. Okay, then when it was the way the patent application was filed, this is the date, 3rd of September 2010. Then this is the international classification. There is a classification system in the patents. Okay, that is the classification system. Then there is other references and other publications. Okay. Then this is abstract. Okay, just like a research paper, its formatting is different in patent document. Abstract of the patent document is different, but this is the abstract of the patent document. Okay. Then this is another again they have its title is there. Then there is a background of invention, summary of invention. What is background of invention? When we get a patent, we get a patent when it is a novel. Okay, our technology is novel. Okay, our talking technology is innovative. Okay, it's not obvious, and it's industrially applicable. So in background section, we have to tell how our invention, what is our background of the invention, how it is different from the previous part, how it is advanced. Okay, so that we cover in the background. Okay, briefly. So then summary of the invention means all the parts of the invention. That is what are the different. It's a brief summary invention. Then detailed description of the invention. Then what is detailed description means all the things in the patent. Okay, how it is produced, what is the manufacturing process, what are the different aspects of the product. Everything should be there in the detailed description. Okay, this is a very important part because a good drafted patent gives a very good rights, very strong rights. Okay, so then examples are there. Okay, examples means if you have a product, then what are the percentage of all the ingredients and what are all the parts of the there in the invention that is there in the examples. Okay. Then this is the claim. Claim defines the boundaries of the invention. I will just come to the claim part in the sections also. So this is the claim. Okay. This is the general patent document. Okay. We'll come back to the presentation again. So just I have shown you the patent document. Okay, second part is the title of invention. Okay, the patent title should be within just 15 words or like that. Okay, or 5 words, 10 words like that. It should not be too long. Okay, then abstract is just telling about the what is there in the patent. Okay, or technical part of the patent. What is it? It's a brief thing. Okay, then the field of invention. Suppose the field of invention tells which field it is from, just like a pharmaceutical or cancer development or chemical compound like that. It includes the field of invention. Then background of invention. Just I have explained background. In patent, we have to explain how it is patentable. So it should be novel. It should have inventive step. It should be industrially applicable. So that part we have to generally explain in this background part. So we have to bring the prior art. Prior art means a research work or a document which is published before you have filed the patent document. Okay. So that is the background of invention. Then summary of the invention. So then what is summary of the invention? What is your product that you are process? You have to summarize it. Okay. Then detailed description of the invention. In detailed description invention, just I have showed in the document everything that is related to the product, all the features of the product, all the processes of the product, drawings and everything. Okay. Then claims. Claim defines the boundary of the invention. Means claims is something. You know land, you purchase land, you know the boundaries of the land. Okay. We call it as the in Marathi Chatur Seema or like that. You know the boundaries. So that there will be a diagram of the land. Okay. Map of the land. So there are the location. Your nearby landowners, they will have their map, and it will differentiate your land very well. Okay, so claim differentiate in your invention from the other research. Okay, it should your research should be new. Okay, so claim is the part which is different from the others. Okay, it's defines the boundaries. Okay, so what is it exactly I'm telling you? I will go further. Okay. So, what is importance of good patent writing? Okay, just you know the this is the technology and you write something, something, something. It's not. There is a certain rules and good tricks to write a good patent, and also skills to write a good patent. So, what good patent gives you? Okay, it defines a legal protection. Means it protect your product or process very well. It reduces the risk of rejection. Means you have drafted it well, it will unlikely to get rejected. Okay, withstand legal challenges means if it is not drafted well, claims are not written well, description is not well, it likely to get um, yeah, in the legal challenges. Okay. Then support licensing and valuation. If it is well written, then you can get a license or and your product is really useful. It will be you will get an opportunity to get licensed or you can get a good value of your patent. So it is clear if it ensures full disclosure, and you will get the benefits of all this. So I have told you claims define the patent boundaries of the patent. Okay, what are the boundaries of the patent? Okay, so as I have told you, suppose take an example of the composition patent. Okay, so just I will tell you what is the parts of the claim. Okay, so claims has three parts. Okay, every claim has three parts: preamble, transition phase, and body. Okay. Preamble means it introduces the invention. Okay, what is it? It's a electronic devices or chemical compound like that. Okay, it's a preamble. Then transition phase. Okay. The transition phase, what is comprising, consisting of, or like that. Okay. If there are some open-ended transition phases, closed-ended transition phases. Okay. What is that? I will come with later. Okay. Then body. Okay. Then body is the main features. What are the different features of the patent or innovation or product or process that it comes in the body? So take an example of the claim. Okay. There are two types of claim: independent claim and dependent claim. Okay. This is the example of independent claim. Okay. Maybe some people may be completely new. They may be understanding something. Some people may be uh, familiar with this patent system, so they may be understanding well. Okay. So mm, you can contact me later, so we can discuss in the that course that Bandu sir has told you. So, what is independent patent? There are two types of patent. Sorry, there are two types of claim. What is independent claim? Okay, independent claim is a claim which is not dependent on the other claim. Okay, so this is the example of independent claim. A pharmaceutical composition comprising a therapeutic. If it's the example, the therapeutically effective amount of compound X and pharmaceutical acceptable carrier. Means it's a formulation. Suppose it is said what is in this pattern. This is the red colored thing is preamble. Okay, comprising it is transition, and then these features are body. Okay, this is how the claims is written. Okay, what is in the preamble? What you know? What is it? What you get to know in the preamble? A pharmaceutical composition. Means from reading this claim, you understood that it is related to the pharmacy, okay, or a composition or a formulation. Okay. From this preamble, you understood this. Then after this transition, what you understood from this transition comprising means it is open-ended term. Open-ended term means it can have multiple components other than this A and B. Okay. This is comprising. This is open-ended term. If you include this consisting of term, it's a close-ended. Means if there is only these two things, nothing else. Okay. This is the difference between open-ended and closed-ended. So Comprising means there can be multiple things other than A and B. If you use consisting, there will be only these two things. Okay. So it defines the boundaries. As I have already told you, claim defines the boundaries of the invention. Okay. So then this is body. What is the body? You understood it is a pharmaceutical composition, means it's a formulation or anything. Okay. So in this, which formulation is this? The formulation of this compound X and also pharmaceutically acceptable carrier. Carrier means vehicle or color or other parts with that compound X. Okay. This is the independent claim. This claim is not dependent on any other claim. So it is independent claim. So what is dependent claim? I have told you there are two types of claim: dependent claim and independent claim. So independent claim, it's completely independent. It stands on its own. So dependent claim is depend on the independent. Okay. Dependent means it depends on some other claim. Okay. So what is dependent claim? Pharmaceutical composition of claim one means this claim is this claim one. This is claim one. Okay. This claim two is dependent on the claim one. The pharmaceutical composition of claim one. Okay. Wherein compound X, which compound? This compound X. Okay. Selected from the group consisting of X1, X2, and X1, X2, and X3 are third things which is not there in the claim one. Okay. These are different things which are in combination with this compound X in the dependent claim. Okay. Why it is called a dependent? Because it is depend on the claim one. Okay. This claim two is depend on the claim one. Okay. Where this claim three, it is also depend on the claim one. This claim four, it is also depend on the claim one. Okay. So here this is the preamble pharmaceutical composition. In this wherein is a transition, and then this is body. Okay. Just like that, preamble, transition, body. This is how we understand the claims. Okay. Then we have understood patent document. Okay. So this is patent document. I have told you. The patent document contains title, abstract, build up invention, background. Okay. So suppose you have developed a product, the patent document will have at least these things. Okay, at least these things. Then what is the importance of good patent writing that I have told you? Then what are the claims? Okay. Okay. So patent document I have told you there is a detailed description which is important to write to explain the invention. Background should be there to explain how our invention is different. Okay. Then there is a claim, it is defines the boundaries. Okay. Then I will tell you like how to search a patent. Okay, how to research different patents. So most of the practitioners or the people working in this field are working on the patent search. People believe that most of the people are working in the patent filing or all these things, but most of the people working in the patent search. Okay, because it's very important. Even before the patent filing, we need to do the patent search. Okay, there are multiple purposes of the patent search. Okay, so why do we need a patent search? Just like you do land search report when you buy a land, you do a you take a search report from the learned advocate or expert. Why do you take research search report? Because who was the owner of that land? Just like this in the patent search report, we need to understand the history of that technology or that invention. So we need a patent search. Okay, before a patent filing, and also other purposes there are requirements in the patent search. Okay, why patent search is required? Ensure the novelty before filing. Okay, this is the first thing that everybody generally knows who does the research and all these things. Then second part is to avoid existing patents and infringement. Okay, so before filing a patent, you have to avoid the other patents. So also infringement means a patent key. It's a chori, theft of the patent in general, simple term. Theft. Suppose you are doing you have a patent on something and somebody copies your technology. Then what did he does? He infringes your patent. Means वो चोरी कर रहा है आपकी. He has done the theft of your technology. उसने चोरी कर दिया. त्याने चोरी केली. बरोबर. A simple word में बता. That is a infringement. Okay. Then what is the use of patent search? Study technology trends and competition. Suppose you are doing a research in particular field or your company is developing some products, you you must be, you must know what is other product, what is other companies are doing, what are they developing. So what they patents they file, from that you can understand it. Okay. Study technology trends and competition that you get from the patent search. Okay. Then how to search a patent. So you have understood why to search patent. Okay. So we have to understand what is, how to um, how to search a patent. So in searching a patent, I will show to you what are the different databases of the patent. Databases means it's a collection of patents or applications or uh, published patent documents. Okay. So I will just take you to the this is in past Google patent, SpaceNet and Wipe. Okay.
Hello.
I am going to the browser.
हाँ,
I'm not
हाँ,
putting
बोलो
any
बोलो
URL.
madam.
Okay. Because I
हाँ,
want to, I want you to see
हाँ,
how from the basic you can do it. Okay. From basic means suppose
आपल्याला
this is a Google.
कंपनीसाठी
You
प्रोडक्ट
have to search
बनवायचा
a
आहे तुमचा
patent.
बनवा म्हटलं
Just
त्यासाठीच
go to the
तुम्हाला हे
Google,
केलं.
type Google patent. Okay. How to search a patent. It's a simple link.
लवकर बनवा
In
तुमचं
the
ते
basic,
आपल्याला
you don't
लॉन्च
need to
करायचं आहे प्रोडक्ट. ठीक आहे.
type any URL in the URL box. Just type Google patent. You'll get this link Google patents.
हा करा करा तुमचे जे चांगले
Suppose
प्रोडक्ट
you have
मार्केटिंग
to
मध्ये
find
दिसतील
a
ते बनवता
patent
बी त्याला
on
काही अडचण नाही.
paracetamol. Okay,
एक
paracetamol related
सेल
patent.
हे करायचं
Then
माझं
you
लागलं.
put
ठीक आहे. मार्केटिंग आणि सेल
paracetamol over. You will get
त्यासाठी
a
कॉल केला मी बाकी काय नाही.
patent related to paracetamol. Okay. How many results you have got?
हम्म.
These are 1 lakh results. Okay. So
चालेल.
this is Google
करा मग
patent.
तेवढं हा, तेवढं लवकर करा मग.
Okay. No, this is not a normal Google.
हा चालेल.
It's a Google patent. You will get a like this. Go to the normal Google, type Google patent, and you will get this website. Okay. Then you type paracetamol. Okay. You'll get a lot of patents on the paracetamol. Okay. More than 1 lakh like this. Okay. So this is for a basic person who don't know how to search patent. This is how we search the patent. Okay. Then okay. Then there is another website is PaceNet. It's maintained by the EPO, European Patent Office. Okay. This website is maintained by the European Patent Office. Okay. So uh, you will get patents from here also as for free. Okay. Suppose you write here paracetamol, you will get a patents on the paracetamol, like paracetamol solution or like that. Okay. This is the patent number. This is the patent details. This is the European patent EP042184. Okay. Then there is the applicant. Whose patent is this? This KDM pharmaceuticals means it's a different language thing is there. Okay. Then this who is the inventor? Who was the researcher of this patent? This Loiter Antony. Okay. Then classification is the technology based thing. Okay. It is suppose this is a classification code. It's related to this technology, health and amusement and all these things. Okay. So it's another part that is classification. You can search it on the Google. But we have the time limitation, so we are not covering this patent classification. But if you are aware, if you are interested, you can go to the Google and search it. Okay. Then this application number, the publication number you get on this website. Also, you can get it from the Google patent also. Okay. Okay. Then another website from the WIPO patent. There are paid databases which charge lakhs of rupees per year. Okay. But why I'm not showing you? Because not everybody able to afford it, and there is no purpose to afford it because free databases are also very good. This is a WIPO patent bill. WIPO means World Intellectual Property Organization. It is governed under the United Nations. Okay. Okay. So this is also governed by the WIPO. There is World Intellectual Property Organization. It is governed by the United Nations. Just you write a paracetamol, you will get a lot of patents related to the paracetamol. Okay, just a thing. So I just wanted to introduce this part. Yeah. It must be taking time. Okay. There are a lot of patent, this patent number and all these things. It's a application. Okay. This is a Chinese document. Okay. Yes. Open a document. Look at that. This is the application number, which is this country. So it is the patent document from the China. Okay. Then there is a Indian government's office. Okay. Suppose you have to search an Indian patent. There is a Indian patent office website. Yet I will show you the our government's Indian patent office website. Okay. Indian patent office. You search it on the Google. Why I'm not giving you the URL dc.com or like that? Because it will be difficult. Okay. This is the Indian patent office website. Here you can patent, design, trademark, GI like that. All the details you can understand. I was telling about the patent searching. You can go to the Indian patent search on the go to Google, search Indian patent search. Okay. We have very much time limitation, so just I'm taking. I don't want to. I want to cover this all the thing. So if somebody is coming here, so he must. So here also you can write the paracetamol. This is the INPA system, Indian Patent Advanced Search System. It is maintained by the Indian Patent Office, that is government office. Okay. So also you can search Indian patents here. Okay. You can, if you are directly application number of patent, you can put here and search it. Okay. There are lot to tell, but we have very much limited time. Okay. So I'm just covering it as early as possible. So when we go in detail, so you will be able to understand very clear. Okay. So if you understand this in this video will be there on the YouTube also. So if something you don't understand clearly, you can ask me on the email also. I have given in the slides. Okay. So you can see it on the YouTube. So there is an impasse that I already showed, that is government website. Okay. So you can search patent application, legal status. Inventors means who are the researcher, filing details, when was the patent, date of the patent filing, and all these things. You can download full patent documents also. In this testnet just I have showed you this testnet. Okay. You can put the keywords. Keywords means suppose paracetamol you put, and you can search the applicant. Suppose you have to search the patent of Google only. If you are interested what patents are filed by Apple or Google, you can write the applicant name there, and you can get all the patents of that particular. Their IPC code, that is International Patent Classification. Just I have showed you that IPC and all these things. And there is something called as patent families. So what is patent family? Patent family is a suppose I have invention or a product which I want to patent. So what I will do, I will file it in India. Then I will go to the US, same technology. Then I will go to the China. There is no concept like universal patent. Once you file, then it is applicable to whole world. If you file a patent in India, it will be applicable in India. Okay. Suppose you are the same technology you want to file in US or in China. So you have to go to the US and file it. You have to go to the China, you have to file. Okay. So, but the family remains the same because main technology is same. You are not filing different technology there. Okay. So main technology. So this is the family member, Indian family member. Same research is there, same invention is there. So it's an Indian family member, US family member, Chinese family member. This is called as a US Indian. This is patent families. Okay. So that you can also get it from the this search databases. Okay. Then Boolean and Boolean search basics. So I will just go in little deep in the search. Okay. So I will go to the how to search a patent. I will go again to the this website. Okay. I just want to show you as a little advanced technique. Just just place the word and you have searched the document. Okay. So in how Suppose you have to search a paracetamol suspension. Okay. Suppose you write paracetamol. Okay. What it what it gives? There is some error is unable to connect to it. Okay. Let's refresh it. Okay. You have found. You have given the result. So on paracetamol, they have shown us how many results? 551. Okay. They have shown us 551 results. Uh, okay, 551 results they have shown. So, suppose you want to search paracetamol and suspensions only, paracetamol suspensions. You write paracetamol and suspension. On paracetamol plus suspension, there are only 7 results. Suppose you write when you have to go specifically with the paracetamol suspension, you can use this and trick. Okay, then you have paracetamol. You write paracetamol. Okay, and no, here it was and. Okay, so it will show you the document which has so your diclofenac spelling is okay. So still there is a error with this. Sorry, paracetamol spelling is also wrong. I was thinking why is there are so less results. So okay, paracetamol. Okay, so if you search only paracetamol, okay, there are certain errors on this website. All text, all field. Okay. If you search paracetamol in all field, okay, there are how many results? 16,240 results are there in all fields. I was just searching in the title field. Okay, there are text field. If you have to search some keywords in the title, you can search in the title after description. Suppose there is a word paracetamol, so you want to search it only in the claims. Okay, if there is a document where in which paracetamol written in claim, you want to search that document, you can search those documents. You can write paracetamol, select your claims, okay, text field claims, and go for it. Okay. So in this way, you can search it. Suppose you have to search paracetamol in claims. We select your claims. In all part of the thing, you get 16,240 results. Now you want to search paracetamol in claims. Means worldwide there are a lot of documents, but documents which cover paracetamol in claims that you want to search. Okay, so you search here, you get 2,433 results. Means there are these 2,433 documents throughout the world in which paracetamol is mentioned in the claim. Okay, so you get this with this. Okay, yet I want to show you what is the purpose of this and use of and in the search pattern search. Okay, search string. So maybe it is going very fast because we have to cover it in the. So suppose we have to we have to search paracetamol suspensions only. So in claim there are 2,433 documents in the claim. Okay, documents where paracetamol is mentioned in the claim. Okay, yeah, you want to search paracetamol suspension. The paracetamol suspension should be mentioned in the claim. You want to search it, so you will get a limited results. 2,300 for 239. Suppose you want to study about the paracetamol suspension only. Why will you search these 2,433 documents? You want to go for the paracetamol suspension, you can read only these 2,239 documents. You have limited this. But when you use or, you will get more than this result, more than this 2000 for, because or is non-limiting. It's expanding to expanding Boolean operator. So you will get means in the document where paracetamol or suspension, both word, either of the word is present. So you get this uh, 10 lakh 60,000 results. Okay. So this is the purpose of and or. And is limiting. When you use or and, it's limiting means either of these, both these words should be there when you use or and when you use or in the search, both words, either of the word should be there. So you get the multiple means these 10 lakh 60,000 document at least have paracetamol or at least have the suspension. Any word should be there. These many documents are there. So depend on the use and or not is used. Okay. So we have very limited time, only 15 minutes are remaining. Okay. There is another Boolean search example like solar and battery, just like we have used paracetamol and suspension. There is another example, solar and battery you can use like that. These are only two words. Sometimes we need to use more than 50 words, 100 words, like 20 words. These are the only two words. When we have to go in very detail, so we have to make a very big search query and or not or other things are there. So there is another search string. This is called a search string. EV, electric vehicle and battery and not hybrid means electric vehicle. We want to search a patent related to electric vehicle. That patent should have battery mentioned in this patent document, but hybrid word should not be there in patent document. This is the search string for that. Okay. Use of and not. By using that, we make the search string, and this is how we search the patent. Okay. Then suppose you put the year. Suppose you want a patent later than 2020. Okay. So you can use such instruction. Okay. There are certain options over there. Then there is a patent analytics. So in this workshop that Bandu sir has told, we are going everything in detail. But now we have very limited time. Okay. So we are explaining as fast as we can. Okay. So it will be also on the YouTube. You can go it there. You can learn detail about it, and you can contact me also if you want to, if you are interested uh, to learn something very specific. Okay. What is patent analytics? So from patents, what you understood, um, if you search a patent of particular company, suppose you search a patents of Google, what you understood, what are the where technology is going, what are different inventions are being done by the Google or Apple. Okay, so you will understood what after 5 years what will be there in the mobile or a headset or a computer. That technology they are planning. If something is coming in next 5 years, they must be patenting it before 5 years. Okay, or they have developed it before 2 or 5 years. Okay, that will come in the mobile devices, the computer after 5 years. So suppose you want to identify what is going to be there in the next 5 years, you find the patents of Google, Apple. You will understand what technology will be there in next 5 years. Okay, so to understand that part, you can learn this patent analytics and all these things. Okay. So what is the benefits of it? Analyze global patent data and find trends. Okay, where technology is going. That trend you can identify. Use in identity R&D, market analysis. How big is the market? Which players are there in the market that you can understand from the patent analytics. Patent analytics means you must be knowing that bar graph, pie graph. Okay, there are graphical systems you use in the research papers and all these things. Okay, that is analytics part. Okay, it helps in competitive intelligence. Means what competitor is doing, what we should do differently, or what advanced things we should do. Okay, that is in the competitive intelligence. Means what skills you need for the patent analytics. Okay, then you need to have science and engineering background. You need to have legal knowledge, tools. There should be patent analytics tools like database, Orbit, Excel. Strong research and communication skill should be there. Then we have only 10 to 15 minutes remaining. Um, so what are the different important points which we have not covered today? There are in the Patent Act. Okay, so we have very limited time, one hour and 30 minutes. So within that time frame, I have tried to explain most of the part. So if a person who is want to learn or make a career, he must know what are the different things are there in the patent system, okay, throughout the world. What are different points under this patent act? There is a opposition system is there in patents. Suppose somebody has filed a patent and you want to oppose his patent. You want that his patent should not get granted. You can oppose it. And there is a compulsory licensing. It is used in the cases of drugs. And there is a revocation of patent. Revocation means somebody has got granted patent. You think he should not get granted patent. You find a previous document or something like that. You want that patent to be revoked. Revoked means removed. You can do this revocation thing. In patent of addition, I have told you if there is already a patent on your name and you want to make a small improvement in it, you can go for the patent of addition. There is a voluntary licensing means suppose you have a patent, you want to license it to somebody means you want to give it on the license and take royalty from it. You can do it licensing. Then there is a government use in polar exams and means it can be used for the research and all part. Then what is patent agent? Okay, that will be covered later. So for the researcher, what are the different careers in the patent field? You can become patent analyst means you do the patent analysis and do your career. Then you become a patent agent where you can file a patents application, drafting and all these things. Then you can become IP consultant. So you can consult the industries how to develop their R&D, how to develop their uh, new products and protect them. Then you can do technology transfers. Means suppose some academics or industry develop a technology, and some other company needs that technology. Okay, that technology transfer can be done in this career. Okay. This is my email, phone number, and all these things where you can contact me to for your queries, for if you want to understand anything in detail, want to file a patents and all like that. This is my contact details and all these things. Okay, so then you can take it for your information, like a snapshot and all these things. Yeah, for your information, take it. So today we have covered a lot of things. It is not possible to cover everything in detail within 1 hour and 30 minutes. You must be thinking that it's going very fast. Okay. But we have to do it because we have to cover it in 1 hour and 30 minutes. You can ask a question in the chat box, or you can make your audio yeah, you can make your audio on. So uh, you can ask the questions. So what we have studied today, we have studied what is patent act in general, what can be patentable, how to search a patent, what is a patent document, what are different parts of the patent document that we have studied in brief. Okay, not in detail. So to do everything in detail, suppose in workshop what we do patent search uh, around 2 to 4 hours. So patent search will be perfect. So we take patent drafting 2 to 4 hours. So patent drafting will be perfect. So we teach patent act in details, every chapter and important section and everything. So we teach patent filing, how patent can be filed. We teach how international patents are being filed. We teach every part of patent documents and all these. What are the kind codes? What are the different country codes? What is patent classification? We teach everything in detail. Okay, so uh, so it's a very detailed syllabus, but we have a time limitation of 1 hour and 30 minutes. You can contact me. My email is there in the if you don't understand anything. So now I will hand over to the Bandu sir for more details because we are running out of time. We have only 8 minutes. As Uh, we have committed we will cover it in the 1 hour and 30 minutes. I am giving last 5 to 8 minutes to the Bandu sir. Bandu sir, please continue.
Yeah, sir, thank you so much to explaining such a typical topic in a simple language in a less period of time. Really, sir,
Yes.
you have taken very less time to explain everything in a very
So it
simple
is
language. Really appreciate
the
your
main.
effort, sir. And I request all audience, if you want to learn in detail how to search pattern, how to draft pattern, and everything. If you want to learn, then please register for this 7 day workshop. And we have very detailed explanation for a given topic, protecting invention, patent search, and Indian patent law. And we have one experienced personality, the Professor Prashant Kharkar from Institute of Chemical Technology, Mumbai. He's drafted his 12 patent by his own. He is a patent agent as well. So we have expert. So guys, and fee is very less. That is 1,500 rupees for 7 days, just limited. Yes, we have. So if anyone register, you can click the link and register. And if you have any question, please ask now. Session is open for question answer session. Thank you.
You can ask any silly questions because somebody may be new, he may be not so expert. You can ask any silly question to any detailed questions. Okay, there is no issue with that.
Yes, sir. I want to ask one question.
Yes.
Can we patent the mobile app? Mobile
Uh,
apps
so so it's a pure program, sir. It goes in the copyright, sir.
copyright. Okay, okay,
Yes. We should go for the copyright because it's a pure program. Okay, it's a computer program, so it
Hmm.
goes to the copyright part.
Okay,
Yes, there is a detailed document by Indian Patent Office. Just let me share it. Uh, Software related, I think, in India. Yeah. Means there is a detailed documents provided by the Indian Patent Office. What is so there are in such case some cases we get the patents on the softwares also, but there should be in combination with the hardware, and there should not be a mere combination. Okay, it should be give the inventive step and obviousness. Okay, so mere making an app, we cannot get a patent, but I will suggest you to go for the copyright.
okay, okay. Thank you.
Yes.
Sir, I have one question. Sir,
Yes.
sir, can we go for the simultaneous patent like India and abroad, like another patent simultaneously?
Yes. Just like I have explained to you, there are two systems, PCT and the conventional system.
Okay.
Suppose you have a patent on particular technology or a formulation or a chemical compounds or like that.
Okay.
You want to file a patent in India. You There is a provision. Suppose you have filed a patent in India, you can file out of India within 1 year by conventional route. There is another provision, that is PCT system, where you have to make PCT application in 1 year, but you get another 31 months to enter in the other countries. That
Okay.
is another PCT system. That is detail part is you will take time. It will take time
Okay.
to. Yes.
That's,
So
thank you.
yes, sir, we can go for other countries with the same technology.
Okay. Thank you.
Sir, another question. I have another question.
Yes.
Suppose I have filed a patent,
Yes.
and suppose there are two versions of it. There is one. Suppose I filed a patent, then one more version is there. Can I file the for both the versions together patent?
No, sir. There is a different part. There is a divisional patent that I have explained to you, but I don't know the details of your patent, so I may not be right person to may not be in position to comment. But I am telling you, if there are two inventions, if patent stand with two different inventive concepts, then there should be a different patent application should be filed. If you filed it together, then controller means patent officer, that is who handles your application. he will suggest you to go for the divisional patent applications. Means there will be a patent application. Yes, there will be a patent, your previously filed patent application. He will suggest you to file another application. That patent application will have different number, different grant number as well. If it get granted, so if it's a different version, I don't know how you are telling what is the version. I may not be in a position to comment specifically, but briefly I am telling you, if there are multiple inventions, you will get a divisional patent application. But if that both version are same thing, so you can go with the one patent application. But I don't know what are these versions, so I may not be in the perfect position to tell you.
Yes, yes. Okay.
And unless I read the your research and all these invention, I may not be able to comment on this.
Yeah, I want to add one point. We are having service of patent drafting. So if you are interested to contact us.
You can contact us.
Uh,
Sir, also there is another question. Can we able to, it's in the chat box, can we able to patent a new methodology or technique developed by synthesizing or formulating? Okay, so methodology, I will take it as a process. There are two types of things which we can patent. There is one thing process and another thing is product. Okay, these two things we can patent. So if you have a he is saying synthesizing or formulating. I am considering it the pharmaceutical thing, suppose for compound or formulation. Okay, so we can patent a formulation or that compound also. We can patent process of preparing that compound or a process of preparing that formulation. Okay, for you when you say methodology or technique, I will consider it as a process. Okay, we can patent a process as well as compound. Okay, or a formulation. So this is the question of Soundara leader CM. I am just I hope he is satisfied, he or she is satisfied with the answer.
okay. So anyone
Yes.
interested for registration? Then let me know.
Not right now. I will contact you.
Yeah, yeah.
Sure,
Thank you,
sure, no
sir.
problem.
No problem, sir. Welcome, most welcome. Okay. If anyone want to draft their patent for their invention, you can connect with us because we are having service for patent drafting. Okay.
Okay.
Yeah.
We basically serve for this patent searching, drafting, and all these things. So anyone who wants to make a career in the as a patent agent or the patent search or anything, you can go with that workshop. Okay. So if somebody wants to learn want specific information, you can contact us. How to it. So learning, we are not charging it directly, as Bandu sir has told me. We are charging it for learning on for value of that work or value of that learning. So that is the system. So you can ask us any questions or anything on the emails and all these things. That is not anything paid. Okay. So Bandu sir, if anything, any question is pending?
No, sir.
Actually, I'm holding myself on patent
Yes.
for
It is sir, it's the application.
pardon me.
It is the application phase or it's a granted patent.
It's a granted patent.
Yes,
It
yes.
is for low water toilet flush.
Okay,
Now
yes.
I designed a toilet flush which cleanses the
Yes.
toilet in 2 liters, just 2 liters.
Yes, 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 yes.
I went through an attorney.
Yes.
There were two times this patent office raised the objection, so it took 7 years,
Yes.
6.5 years.
Yes, yes, yes. It's too
Finally
long. Yes.
granted, and it was to going through an attorney. It was
Yes.
expensive, so that is why I want to learn how to file myself. So I will try
Yes.
to join.
Sure. No problem,
Yeah.
sir. You
So
can
most
join it.
welcome. Most
Yes,
welcome.
it's you are most welcome, sir. Because learning is most important in this system. Sometimes we face that inventor hide something from us, or he deliberately try to hide something, which is very important in getting patent granted. So learning is most important thing. You can make career as a patent agent. Also, you can help others for filing patent and all these things.
Okay.
In India, the patent agent exam, which is conducted generally annually, but sometimes they take a break of 1 year or 2 years, and after they conduct this patent agent exam. So patent agent basically can file patents for others. Okay, and he can avoid this.
Qualification, patent agent examination pre-qualification. What is the
It's
necessity?
any science degree, sir. You should
Science.
be yes, you should be citizen of India. You should hold a science degree,
Okay.
and uh, then you should be about 21 year old like that.
Yeah, actually, sir, we are conducting that examination preparation session as well in coming days.
Yes,
So
Okay.
how to
once that
prepare
exam,
for patent agent? How to prepare for patent agent? We are going to conduct that session in coming days.
Okay. Yes. Thank you.
it's needs preparation of few months because in legal language you need to understand it well.